First, I'll go forward with the introduction. Then, I'll discuss the Hindu undivided family. Then, I'll explain about joint family property. Then, coparcenary property. And I'll distinguish between joint family property and coparcenary property. Then, we'll discuss self acquired property. Then, I'll be concluding my lecture. The Hindu law deals exquisitely regarding property ownership, inheritance, and succession. The laws are like cobwebs, complex, but I'll break down and make it as simple as possible. The laws have emerged from smritis, judicial decisions, and legislations. Mitakshara and Dayabhaga are the two schools of Hindu law. Under Mitakshara, the right to contest for a property arises through birth, and under Dayabhaga, it will arrive only after the death of the last owner of the property and after the Pinda offerings. The objective of this lecture is to help you understand the joint family property, coparcenary property, and self-acquired property. We'll also come to know how devolution of property happens upon the heirs. The heirs can be class 1 heirs and class 2 heirs. Class 2 heirs includes cognates and agnates. Class 1 heirs are son, grandson, wife, and daughters. Class 2 heirs can include maternal aunt, paternal aunt. An agnate can always be a male, like father's father or father's father's brother, like that. The Mitakshara law has recognized apratibandha and sapratibandha property. Apratibandha means unobstructed heritage and sapratibandha means obstructed heritage. Let me illustrate regarding obstructed heritage. Let us suppose that A has inherited certain property from his brother who died issueless. The question is, will sons of A inherit the property during the lifetime of A? The answer is no. The sons will inherit the property only after the death of A. This is an obstructed heritage. Now let us understand unobstructed heritage. A inherited property from his father. He has two sons, M and N, who are co-partners with him. M and N will acquire an interest by birth in the ancestral property possessed by A. The property in the hands of A is unobstructed heritage, as the existence of the father is no obstruction or impediment to the sons acquiring an interest by birth in the property. The Hindu law, that is the Manusmriti, stated that the eldest son should take over the patrimony and the brothers are subservient to him. Before we understand joint family property, coparcenary property, and self acquired property, let us understand Hindu undivided family. Let us suppose that Dadaji has been selling mangoes in his orchard. He is doing that with the help of sons, unmarried daughters, wife, as well as grandsons. All these people will be considered to be a part of Hindu undivided family. The income that they generate through selling the mangoes will be considered to be HUF income. Let us suppose that one of the son wants a separate share. He will get a share equivalent to his contribution towards the Hindu undivided family and not beyond that. Thus, a Hindu undivided family is a legal entity consisting of lineal descendants from a common male ancestor including their wives and unmarried daughters. So, the unmarried daughters and sons will be considered to be coparceners, but the sons' wives will be considered to be member but not a coparcener. Let us suppose that Dadaji also adopted few children. They will be considered as members but not coparceners. A Hindu undivided family has been recognized under the Income Tax Act. A coparcenary right is a narrower term as it doesn't include adopted children within its ambit. It is just the lineal descendants from a male ancestor who will be considered to be coparceners. Daughters were not co-parceners before the 2005 amendment to Hindu Succession Act, but they became equal co-parceners after 2005 amendment. Daughters have equal rights over the property today. Families emerged joint families. From joint families emerged clans. From clans emerged tribes. From tribes emerged kingdoms. From kingdoms emerged empires. And from empires emerged government through democracy. We were families before anything. Family is a bedrock of a modern society. Joint family consists of lineal descendants from a common ancestor and includes wives and unmarried daughters. To constitute a joint family, there need not be a property. If a family is holding goods or articles in common, then that itself can constitute a joint family. The family here should consist of persons linearly connected through the male line, that is, sons, grandsons, and collaterals can include brothers' children. Any person related by adoption can mean adopted children, and dependents can mean even widows of sons. It includes even maiden daughters, that is, unmarried daughters. So, if a family consisting of these many members hold goods or articles in common, they themselves will be considered to be joint family without the existence of property. Joint family arises through sapindas who have come into existence through birth, marriage, and adoption. If this joint family holds a property, then that will be considered to be a joint family property. Let us now understand coparcenary. Then we'll come to coparcenary property. Coparcenary consists of only male members up to 3 generations. Thus, it includes sons, grandsons, and great grandsons. The interest to devolve the property upon themselves arise through birth upon the coparceners. Under Dayabaga, a woman could become an heir to the property only if there were no coparceners, that is, sons, grandsons, or great grandsons. The coparceners hold the property in joint and enjoy it until a partition is effected. The essential features of coparcenary are there are only male descendants and the co-partners can demand a partition, and until then the property will be held in joint. A co-partnership property could be alienated only in case of necessity. The Manusmriti says that a grandson is entitled to repay the debts of his father as well as his grandfather. The debts should be made only through legal means. Debts which arises through illegal means such as prostitution or gambling was held to be not proper debts, and the grandson was not entitled to repay these kind of debts. On death of a co-parsoner, the property would go to the heir through the rule of survivorship. The rule of survivorship states that a co-parsoner is entitled to get the property automatically. But if there is succession, then the property will devolve upon the heir only after a will or intestate succession comes into existence. Joint family property or the coparcenary property are classified into ancestral property. Let us suppose that X has inherited property from his grandfather. This is an example for an ancestral property. If this property will devolve upon three generations, it becomes a coparcenary property. Second one is property jointly acquired by members of joint family. Raghav and Sugriv acquire property jointly. This becomes a property held jointly by people belonging to joint family. Third is property thrown into common stock. Let us suppose that X buys a flat and he says that he is no longer the owner of the property and gives it to general public. This is a property thrown into common stock. Fourth one is property acquired with the aid of joint family funds. Let us suppose that a family owns a property. From the property's income, they acquire a piece of land. That also becomes a property acquired with the aid of joint family funds. All these classifications are included within the ambit of joint family property or coparcenary property. Let us discuss the distinction between joint family property and coparcenary property. Joint family property is a broader term compared to coparcenary property. Coparcenary property consists of only male members up to three generations, that is, sons, grandsons, and great grandsons. A woman could become co-parsoner only after the 2005 amendment to New Succession Act. The co-parcenary property comes to an end upon the death of a co-parsoner. It devolves upon the heirs on the rule of survivorship and not through succession. A coparcenary can be a joint family property, whereas a joint family property cannot be a coparcenary. Let us now discuss self-acquired property. Self-acquired property includes under its ambit property acquired by Hindu by his or her own exertion or effort. Moreover, there will be a profession through which he will have earned the income, and that income will have been extended towards property building. That's why it will be regarded as self-acquired property. The second one is property inherited by a Hindu from any person other than his father. A share in the joint family property will be considered to be self-acquired property. A property devolving upon co-parcener, provided there is no widow who can adopt or give birth to his heir, will be considered to be a separate property of that Hindu. A property obtained by will can also be considered to be a self-acquired property. and a property obtained through grant by government will also be regarded as self-acquired property. What about gains of learning? Any income earned by a member of joint family substantially by his education or specialization, expertise, or special intelligence would be regarded as his separate property. Let us suppose that X, who was educated by joint family funds, ends up gaining knowledge in artificial intelligence subject and develops a robot. That robot will be considered to be his separate property and not that of the joint family. I would like to conclude by stating that joint family is a broader term compared to coparcenary. Coparcenary is restricted to only male members in three generations, that is, son, grandson, great grandson. A self acquired property is one which a Hindu acquires through his own efforts and exertion. And there are other categories of properties which are considered to be self acquired property as discussed in the previous slide. A Hindu undivided family, if it is considered to be a bigger circle, JFP, that is joint family property, co-parcenary property, these two will be considered to be the smaller circles within the HUF circle. And self-acquired property is a separate circle all around. But if the joint family property is divided through partition, then the share of a co-parcener will be considered to be his self-acquired property. Thank you for listening to my lecture on property under Hindu law.